Hello everyone. This video is about the Companies Act 2013. Firstly, we have to understand which are the important sections for our exam point of view. And the exam we are going to appear in 11th of January 2026. So for that exam, CBI APP, CBI PP, etc. So firstly, we have to done chapter 14. Chapter 14, these are the sections are important for exam point of view. That is why I have written here first. Thereafter, you have to complete chapter 1. Chapter 1, under chapter 1, there are definition clauses. And thereafter, section 6 to 7, 23, 34, 36, and 42, these are the part of second, secondly, you have to done these sections with chapter 1. Firstly, we have to done chapter 14. Thereafter, we have to done chapter 1, including the definition clauses and including these sections. Thereafter, chapter 5 has to be done. Thereafter, chapter 17 has to be done. Thereafter, chapter 20. Thereafter, chapter 18. Thereafter, chapter 7. Thereafter, these sections have to complete these sections. Thereafter, chapter 12 has to be 12 has to be completed. Thereafter, chapter 12 has to be completed. These are the symmetries, because it is depend upon your time. If you have a time, you have to do all the sections in brief. But if you do not have a time, but you are going to appear in exam, then these are the way you can understand this chapter. You have to complete this chapter by this symmetry only. So if you have done this chapter 18 is important, chapter 19 is very important. These are the ways I have symmetrized that how we have to complete this chapter with important case laws. So firstly, I just want to the list of the cases which are important for our exam point of view. These are this is the fundamental case of Companies Law Act. It says that establishment of fundamental principles of separate legal entity with regard to the company. Company is a person independent of its shareholder. This case held at. Thereafter, Lee versus Lee Air Farming Limited 1960, it says that a person can both be a sole governing director and an employee of the same company, reinforcing corporate personality. Thereafter, we have to do Daimler Company Limited versus Continental Tire Rubber Company. It introduced the concept of lifting the corporate veil during the wartime to determine the enemy character of the company based on those in de facto control. So you are UPSC having a habit of asking the case which are dependent upon certain type of concept. Like in a company law, there are basic of some basics which are based upon some case laws. Even these case laws are very old in nature, but UPSC having a habit to ask these case laws. So we have to complete that case laws. Thereafter, Royal British Bank versus Turcond established the doctrine of indoor management and protecting outsider by allowing them to assume that company's internal procedure have been followed correctly. Thereafter, Ashby Railway Carriage and Iron Company Limited versus Riche, it defined the doctrine of ultra vires that if anything done out of the preview of a memorandum of association, it may be considered as a void and cannot be rectified by even a special resolution. That may considered as a doctrine of that act may be considered as a ultra virus. It is a latest case, Tata Consultancy Services Limited by Cyrus Investment Private Limited. In this case, Supreme Court says that the removal of chairman does not automatically constitute operation under Section 241 unless it is proven prejudicially to the company or its member. Thereafter, Shanti Prasad Jain versus Kalinga Tubes Limited, 1965. It is a old case of Supreme Court, but it is important for understanding the concept of oppression as a lack of probity and fair dealing in the company's affair to prejudice some members are called as a oppression. Thereafter, our latest case, Sirish Vinod Shah versus Bharati Telecom Limited. It says that the NCLAT ruled that a minority shareholder have no vested right to remain shareholders during the valid capital reduction approved by the majority. If the capital is reducted by approval of majority, then the shareholder does not have a right to be remain in that company. Thereafter, L&T Finance Limited versus Ticona Infitech Private Limited. This judgment is delivered by one of the bench of NCLT, which clarified that a compulsorily convertible debentures qualifies as a financial debt under IBC if there is a binding obligation to pay interest. Thereafter, there are leading cases on serious fraud investigation, office bail condition, the constitutional validity of the power of arrest and finality of investigation report. The first case is SFIO versus Aditya Sharda. In this case, Supreme Court talks about anticipatory bail under Company Law Act. It says that there are twin conditions for bail under 212 subclause 6 of Company Act, which require the court to satisfy that accused is not guilty and not likely to commit another offense. Then this requirement has to be strictly followed, and in this case, Delhi High Court had granted bail, and the Supreme Court set aside that bail order, and accused history of evading legal processes has to be entertained by the Supreme Court, and the bail of anticipatory bail of Aditya Sharda was rejected, which was given by the High Court. Thereafter, SFIO versus Nitin Johri, 2019 Supreme Court case. It is a landmark judgment of twin condition for the bail. Supreme Court cancelled the bail of Delhi High Court. The same case which have already in Aditya Sarda case, the same facts are under consideration in SFIO versus Nitin Johri. It also defined Section 212 subclause 6 of Company Act. It says that the Company Act has to be read in addition to general bail principle under CRPC, which is now a BNSS. The court clarified that the magnitude of the fraud and gravity of the offense are critical factors in denying bail in economic crimes. Thereafter, SFIO versus Rahul Modi, it is also held by Supreme Court that in the investigation report is submitted after a prescribed period. Let's say that central government asks SFIO to complete the investigation in a time-bound manner. They have also prescribed the time period like 2 months, 3 months, 4 months. But the SFIO could not give a full investigation report within said prescribed period. The Supreme Court said the entire investigation does not become a void or invalid even if it is submitted after the prescribed period. It also clarified that SFIO investigation report filed with to the special court is deemed as a police report charge sheet under 173 CRPC, which is 193 BNSS. Now, the time frame mentioned in such order are generally directory rather than mandatory. It says that sometime central government asks SFIO to file a charge sheet before them. So if SFIO is investigating some matter with regard to the Company Act, then they have to file interim report to the central government. Thereafter, a full-fledged police report before the central government, and then central government take a opinion of legal experts. Then only they can ask the SFIO to file the same with the special court. That is the procedure given under Company Law Act. Thereafter, fourth case is SFIO versus Neeraj Singhal. In this high-profile case involving Bhushan Steel, the Supreme Court stated the Delhi High Court order that has granted interim bail. Interim bail has been granted by the Delhi High Court, and this case settled that SFIO officers have a power to arrest individuals based on a material in their possession if they have reason to believe that the person is guilty of a fraud punishable under Section 447 of Companies Act. It talk about the power of arrest of SFIO. This case is about the power of arrest to the SFIOs. Thereafter, Barum Chemicals Limited versus Company Law Board 1967 Supreme Court. This case is very important, which says that the section 210 and 213 are fundamentals, even though the same provision has been provided under 1956 Act, but with the different sections. Now, since we have a 2013 Act, the same provision has to be followed as like the 1956 Act. The Supreme Court established while government's opinion to investigative is subjective, it must be based on relevant material suggesting fraud or mismanagement. It says that whenever a central government asks the SFIO or any investigating agency to investigate the matter with regard to the company law, then certain provisions which are available in 1956 Act has to be read under 2013 Act, and which specifically under 210 and 213 has to be followed as like the sections are followed in 1956 Act. Thereafter, Tata Sons versus Cyrus Mistry, it says that larger focusing on section 241 section, this case has already been done. We have already been done this case. The court clarified that tribunals have a limited power to interfere with the internal corporate governance unless actions are proven oppressive or harmful to the public interest. It underscores that a statutory investigation must meet specific threshold of public interest and prejudice. It says that central government does not have a power to take a help from any clause and ask the SFIO to investigate the matter. That clause must be satisfied before asking the SFIO to investigate the matter. Or SFIO does not have a power to investigate by own. They have to follow the procedure. They have to follow the procedure under Company Law Act, whether it is a public interest or prejudice. It is not always on a vague allegations they can investigate. It must satisfied with a subjective approach that there are certain reasonable circumstances under which that investigation has to be done. Then only the investigation has to be done. Otherwise, they cannot investigate the matter. Moser Beer India Limited, this case decided by Delhi High Court in 2025. It says that the SFIO investigation was set aside. It relied on non-existence ground and misread forensic audit report. The ruling affirmed that the statutory necessity for SFIO involvement must be clearly established. On a vague grounds, the SFIO cannot investigate the matter. This case is all about that. Thereafter, HDFC Bank Limited versus Registrar of Companies, Bombay High Court says that inquiry under 206 Clause 4 was invalidated because there was a lack of evidence of fraud. The court noted that initiating such proceeding based on irrelevant on unconnected complaints is misconceived. This is also the same case as we have already read Moser Beer. Thereafter, Neetapuri versus Union of India. This case is it quashed the SFIO investigation order because it failed to mandatorily reflect the necessity of investigation in a public interest as required under Section 212, Subclause 1, Subclause C. The court emphasized that the government must have concrete material to form an opinion for an FSIO probe. So, in every case, we have listed some cases in which the power of SFIO was rectified or was approved by the Supreme Court or Delhi High Court, or they also ordered that it is not a power of SFIO to make investigation on vague terms. They must have a concrete material, concrete evidence to initiate the proceedings. Thereafter, Mrs. Shelja Krishna versus Satori Global Limited 2025. In this case, the Supreme Court held that NCLT possesses wide jurisdiction under Section 241 and 242, that is, operation and mismanagement. It is not barred from adjudicating complex allegations of fraud, manipulation, and coercion in a claim of mismanagement, even if these involve the validity of instrument like gift deeds used for share transfers. Thereafter, Aruna Oswal versus Pankaj Oswal and others 2020. In this case, the Supreme Court ruled that when a question of right, title, and interest in shares due to nomination is pending for a civil court, a petitioner cannot maintain a operation or mismanagement petition under Section 244 of Companies Act until their title is clearly established. In this case, Mr. Aruna Oswal uh, went for Supreme Court and asked the court that there is a operation and mismanagement in a company, but at that time he does not have a right, title, or interest in a shares because that issue was already been pending in a civil court. That civil court has not decided that right, title, interest of that person. Now he want the court to interference within the company's management, that it is a operation and mismanagement, and that petition was made by that person even though he does not have a right, title, and interest not decided yet. The Supreme Court said that when that petition is pending before a court, then that person cannot make a petition with regard to 244 with regard that there is operation and mismanagement in a company. The petitioner cannot maintain an application under Section 241 and 422, Operation and Mismanagement of the Companies Act, if there is an entitlement to the share is under cloud of pending civil dispute. So there must be some eligibility threshold under Section 244. Court noted that the respondent Pankaj Oswal did not hold the requisite 10% shareholding necessary to file a petition. The court ruled that it would be inappropriate to grant a waiver of this requirement while the underlying ownership of the shares was still being litigated in a civil suit. Thereafter, Union of India versus Delhi Gymkhana Club. This case was decided by National Company Law Tribunal NCLAT Principal Bench, Delhi. Appeal is pending before a Supreme Court. In this case, the public interest under Section 241 Clause 2 was clarified by the NCLAT. The court held that the tribunal held that even a small segment of society, such as the potential club members, constitute a public interest, allowing the central government to file a petition if the company's activities are harmful to them. Thereafter, Arun Kumar Jagat Ramka versus Jindal Steel and Power Limited 2021 Supreme Court. In this case, Honorable Supreme Court says that a promoter disqualified under Section 29A of IBC are also ineligible to propose a scheme of arrangement under Section 230 of Company Act during liquidation. Thereafter, State of Bihar versus Zikitza Healthcare Limited 2024 Supreme Court. This case is very important. It says the explanatory notes to the accounts. The word notes to the account are considered as an integral part of company's balance sheet under section 134 subclause 7, and failure to include them can lead to technical disqualification in public tenders. So whenever any company want to get a tender, so any person want to get a tender from a company, then under section 134 subclause 4, there must be one qualification with regard to that. He must notes to the accounts. Explanation has to be given by that person. Thereafter, SEBI versus Mukesh D. Ambani case, it says that the managing director cannot be held vicariously liable for the company's civil violation unless specific evidence proves their involvement. Thereafter, Asarish Vinod Shah HUF versus Bharati Telecom Limited 2025. NCLT, this decision was given by NCLT, principal bench of New Delhi, because the appeal already dismissed by the Supreme Court. So this case may be considered as a the case of Supreme Court. It was ruled that a minority shareholder have no vested right to remain shareholders if the capital reduction is approved by special resolution and is neither unfair nor illegal. Thereafter, Piyush Natwarlal Patel versus Delta High Tech Coating Private Limited 2025. This is also a decision by a NCLT of Ahmedabad bench, that shareholders have absolute statutory power to remove directors provided they follow correct procedural formalities. There is a one case based upon insolvency and bankruptcy code, Swiss Ribbons Private Limited versus Union of India. It was a very leading case decided in the year 2019 by Supreme Court. It checked the constitutionality of IBC Act. It also says that there are certain provisions which are to be held mandatory under IBC, because there are uh, two types of creditors given: financial creditors and operational creditors are given under IBC. So Supreme Court says that if these two creditors are mentioned, it does not have a arbitrarily or discriminatory uh, these words are not discriminatory in nature under Article 14. Financial creditors are better equipped to assess the long term availability of business, whereas the operational creditors primarily seek immediate payment of goods and services. This case is not important for our exam point of view, but since it was a leading case on IBC, there are certain areas of company laws also uh, hit under this case. In this case, the court clarified that NCLT can set aside a COC rejection if it is arbitrary. So there is some check and balance upon the power of COC by NCLT. Uh, in this case, the conclusion of this case is that the defaulter's paradise is lost. In its place, the economy's rightful position has been regained. That is the ratio of this case. These are the cases generally we have to cover under Company Act. So in second video, I will cover the important provisions which are for important for our exam point of view. Thank you so much.